Welcome back to Good Law, Bad Law. We are hearing more and more about the rise of hate crimes in our country in recent years. Some of them are being prosecuted by government authorities, but on this episode, we're going to focus on the story of one victim of a hate crime, the former student body president, the first African-American female student body president at American University in Washington, D.C., and how she stood up and won in court against the neo-Nazi organization that had targeted her. And the lawyer who represented her, my guest on this episode, Kristen Clarke, who's the president and executive director of the National Lawyers Committee for Civil Rights Under Law, a career fighter for civil rights in New York State, in the United States Department of Justice, and now at the helm of this important national civil rights organization. A great and inspiring conversation about how some are now standing up to hate crimes and the trend that we hope this sets for the future. Great conversation with Kristen. Stay tuned. There is a new front in the fight against hate groups and the hate crimes they commit, and that new front is the courthouse and the courtroom. And my guest on today's episode is going to tell us about a recent victory that she had on behalf of a client against a neo-Nazi organization and their website in particular. My guest, Kristen Clarke. Kristen, thank you so much for being on the program.
Thank you for having me.
Kristen is the president and executive director in Washington of the National Lawyers Committee for Civil Rights Under Law. And according to the reports that I've seen, and Kristen, you're going to tell us a lot more about this, but you very recently had a victory in court against a neo-Nazi website and a couple of students, and won a $725,000 judgment in court on behalf of the former president of the student body at American University in Washington. So congratulations on that, and I'm looking forward to hearing all about the case. Can you perhaps start by giving us a little background on yourself? You've had an incredible and hugely successful background even before coming to the National Lawyers Committee, and also on the work of your organization, what you do and the kinds of work that you guys do.
Yeah, thank you again for having me. I'm a longtime civil rights lawyer. I've been doing civil rights work for every day of my career. I started off at the Justice Department in the Civil Rights Division. I spent some time at the New York State Attorney General's office enforcing civil rights laws across the state of New York. Worked at the NAACP Legal Defense Fund, and it's been a real privilege to be at the helm of the Lawyers Committee for Civil Rights Under Law at such a trying time for our country. Our work is very broad in scope. We fight voter suppression and run a program called Election Protection, which is the nation's largest nonpartisan voter protection effort. It's anchored by the 866 Our Vote hotline, and it emerged in the kind of aftermath of Bush v. Gore, when we realized that we needed a mechanism to really keep on top of a lot of the breaks in our voting system. We needed an outlet for people to go to report complaints, and we needed something that was not partisan in its makeup. And so Election Protection has been running strong for about 18 years and is a go-to resource for voters across the country who face barriers to the vote. Beyond voting rights, we work on fair housing, education, criminal justice, and much more. But our work to fight hate crimes really occupies a great deal of our time and energy right now, given the events that are unfolding across the country. And then if I could just take one quick step back to talk about how we came about. We were founded about 56 years ago when President John F. Kennedy put out a call to action to the private bar. He convened a meeting at the White House of private lawyers across the country and basically put out a charge to them and said, you're not doing enough to engage in the civil rights fight. And many of those private lawyers were situated in places where there were critical fights unfolding across the country. He told them, roll up your sleeves, go back to your home communities and figure out how you can start using the law to come to the aid of victims of discrimination. And many of them did just that. They started to take on cases protecting the rights of people engaged in sit-ins, protecting the First Amendment rights of people who were marching for the right to vote, and people who were facing police violence and much, much more. That kind of call to action really defines the DNA of our organization. We are a civil rights organization that is about fighting to defend the rule of law in partnership with the private bar.
And how do you get the private bar involved in the initiatives that you have and some of the cases that you work on?
Yeah, it's a good question. So I have a very big board comprised of about 240 lawyers. The number has historical significance. It mirrors the number of people who met with Kennedy at the White House. They represent about 150 law firms across the country, and when we need them, we put out a call to action. And in many of these law firms partner and co-counsel with us in the cases that we bring. And so the case involving Taylor Dumpson that we'll talk about today is no different. It's a case that we brought in partnership with a law firm here in D.C. That infusion of pro bono support is what helps us to fight with fury all around the country and do our very best work in safeguarding the rights of victims of discrimination.
Okay, well, let's talk about the Taylor Dumpson case, because I want to leave some time at the end of our conversation to step back from the specifics of this case and look down the line some, Kristen, and ask you, about the significance of this case and where you think challenges to these types of hate groups, is going in the future. But tell us the story, because it's such an important story, I think. In that, as we know too well, it's not unique. This is not a one-off case, but an important illustration of the kinds of things that are happening more and more around the country. So give us the background on Taylor's case and how it proceeded then.
Yeah. So Taylor was American University's first African-American female student body president. She was elected in 2017, and she's bright, she's brilliant, and a real star and a leader in the making. And the moment that she was inaugurated into that role, she became the target of a number of hate crimes. Nooses were hung around campus. Banana peels were hung with racial slurs written on them, slurs describing her as Harambe bait, for example, and statements referring to her historically black sorority.
And Harambe, just so in case anybody doesn't remember this, Harambe was the name of a gorilla at a zoo in the Midwest, right?
That's right. Mm-hmm. That's right. And the Daily Stormer is a neo-Nazi website that was founded by someone named Andrew Anglin. They targeted her and kind of led this campaign. They doxed her, meaning they published her contact information and social media profile online and directed their army of internet trolls to go out and harass her. And they did. They published where she would be on campus and sent her harassing messages, racist messages, with threats. And this had a toll on her. She was formally diagnosed with post-traumatic stress disorder. She suffered anxiety and depression. She began to worry about walking around on campus and off campus. She started to carry pepper spray with her at night. She lost about 15% of her body weight. D.C. Police Department investigated and determined that these incidents were indeed hate crimes. But we were the ones who stepped in to kind of fill in that gap and fight for justice on behalf of Taylor. And what we did was we did something that was novel. We used D.C.'s public accommodations law. Our nation's public accommodations laws arose during the heyday of the civil rights movement, when Black folks were denied access to sit at lunch counters and denied the right to stay in hotels, etc. Our public accommodations laws basically make clear that all people enjoy access to these kinds of public establishments regardless of their race. And D.C.'s public accommodations law is what we used here. We basically argued that American University is a public accommodation. There are restaurants on the campus. There are places for people to stay. And she should enjoy the equal opportunity to, access that campus regardless of her race. But the Daily Stormer and its racist troll campaign and harassment of her denied her that right. The court agreed with us, and so this essentially is the first time that a federal court has recognized that online harassment and online trolling is the kind of activity that can interfere with someone's right to equally enjoy access to a public accommodation. So we're excited about the victory for Taylor, but we're also excited about kind of opening up this new avenue for fighting white supremacy and online harassment elsewhere in the country.
That is a fascinating legal approach to this, and I want to make sure people understand how this works. You mentioned that the D.C. police determined that the activity of not only this website, which is, by the way, and I'm a historian of World War II and the Holocaust, I mean, the Daily Stormer is the English translation of the Nazi newspaper Der Stürmer. It's the same name. Not only found that the activities of this neo-Nazi organization constituted hate crimes, but a couple of students who were identified as having acted on the incitement from this website and the people behind the website, that those were found to be hate crimes, meaning what? That as a matter of criminal law in the District of Columbia, those were deemed hate crimes. Is that right?
Yeah, but this is not just, offensive words. This was, activity that truly caused fear, deep fear. I mean, she did not feel free to walk around campus at night or day. She, had her hand on pepper spray at night. Her grades suffered. She was diagnosed with PTSD. This was a real criminal act. And we can't sit back and wait for this Justice Department to do all of the work that must be done to combat hate crimes. We want them to do more, but we recognize that as civil rights lawyers, that we have an obligation and a role to play here. And so this is us using the available tools that we have in our arsenal to fight back white supremacy at a time where it's truly intensifying across the country.
Well, let me ask you too, Kristen, because I know that some people may be wondering about the First Amendment and how that intersects with these issues. I mean, we have a long history in our country of the First Amendment protecting even hateful or despicable speech. But you're describing something that I think we're hearing more and more about in these times, where speech crosses over to incitement to violence, or incitement to harassment, or some incitement to hate conduct beyond just despicable or offensive words. That's something that the First Amendment does not protect. Can you say a bit about that and how that played out in your case?
Yeah, I mean, the First Amendment is one of the most important rights in our democracy, and we carry out our work with great faithfulness to the First Amendment, and none of the activity that we are focused on in the scope of our hate crimes work is activity or speech protected by the First Amendment. When white supremacists instruct their followers to go out and harass, when they publish someone's contact information and social media profile for the sole purpose of harassing someone on the basis of their race or their gender, we're no longer in a zone of activity protected by the First Amendment. This is activity that is criminal, and we need prosecutors across our country figuring out how they can stand in the gap to do more. But at the end of the day, when you interfere with someone's rights on the basis of their race or their gender, we have an obligation to stand up for people victimized by that kind of conduct and insightful activity.
So you're calling on, from this experience, calling on prosecutors at the state and I assume also at the federal level to take greater involvement in prosecuting criminally this type of incitement and therefore this kind of hate crime. But your case, just again to make sure people understand the difference here, you pursued a civil case on behalf
That's right.
of Taylor.
We pursued a civil case, and as you noted, secured a $725,000 judgment against the defendants. And we hope that very substantial judgment sends a strong message to other white supremacists across the country that they cannot act with impunity and may also be held accountable for their actions. We are leaving no stone unturned in combing their assets and doing everything that we can to collect on that judgment. And we hope that it helps to take the wind out of the sails of other white supremacists, and in particular the Daily Stormer. By no means should there ever be a moment where it's business as usual for them in the face of this judgment and other judgments that are now on the books against the Daily Stormer.
Right, there are a couple of others too, yeah.
Yeah, they have to pay up. And so, the criminal process is one way to send a message, but these substantial judgments that we're getting in the civil context and other forms of relief, we think, are another important pressure point in the fight to beat back white supremacy.
Well, and there's no doubt, and of course there are technical legal differences between a criminal prosecution and a civil case for money damages, but I wonder what you think about this too, that it's one thing when a government prosecutor brings a case, but it strikes me that there's something about the individual who was injured here, Taylor, having a way to stand up for herself, obviously with the help of a committed lawyer and the supporters of your organization. But there's something about this story that is also about a citizen, an individual standing up and pushing back on this kind of conduct and actually winning in court. And what does that feel like? And what is the significance of that?
Oh, it's tremendous. It took great courage and wherewithal for Taylor to stand up and fight back, given all that she had endured and been through. And I want to really underscore, that she's very much a hero to me and for many of my colleagues around here, because we saw firsthand the impact that this devastating experience had on her. And for her to muster the strength to kind of put herself out there and, stand up for herself to vindicate her rights was no small step. And my hope, and I think her hope, is that there will be others out there who can use her story to also find hope. Hate crimes so often happen and there's no accountability. No one's brought to justice, and I think it sometimes discourages people from reporting and from most certainly from fighting back. So our hope is that there will be other people who seize on her story and realize that you can do something, that you can stand up, even in this dark and turbulent era, and use the law to hold perpetrators accountable. And at the Lawyers Committee, our Stop Hate project is growing every day. We're one of the only national racial justice organizations engaged in work to beat back hate crimes in a comprehensive way. We have an 844-9 No Hate hotline where we are out helping victims and connecting communities with resources. But we're also using the law every day to hold perpetrators and social media sites accountable for their role in the crisis that we're up against today.
And that's fascinating to me, because I know that's been a much talked about aspect of all this, which is the role of social media platforms and whether they can be held accountable for the content or for failing to appropriately monitor the content on their platforms. Do you see that as a new front when it comes to bringing civil cases against groups like these neo-Nazi or white supremacist organizations? Their websites have to exist somewhere. Their posts have to exist somewhere for them to have a reason for being. And do you see that as a part of future litigation activity?
It's not just a part, it is critical. Today's white supremacy fight that we face in 2019 is a little different than what we were up against in decades prior, and that's because white supremacists are using online platforms to basically turbocharge their efforts. They're using online platforms to spread violent, insightful messages that go viral, to recruit at lightning speed, to fundraise, to target victims and dox victims by publicizing their contact information and instructions to their followers to go out and harass them. So if we're going to beat this fight, we have to bring more pressure to bear on online platforms to do their part. Let me just take a moment to talk about work that we did with respect to Stormfront.com. That's one of the biggest hate sites in the world. It's been up for more than 20 years. They've got over 300,000 registered users from across the globe, more than 1 million people who frequent the site. And shortly after Charlottesville, we decided to take action. Stormfront is housed on the web through a company called Network Solutions. Their parent company is web.com. And that company has an acceptable use policy that consumers agree to whenever they purchase their services. And that policy says that consumers who use their services are prohibited from displaying bigotry, discrimination, racism, or hatred, and more. And as a company, they're free to have such a policy. It's a sensible policy, but it's useless unless enforced. And so we went to Network Solutions and we said, here are over a dozen examples of murders that can be traced back to Stormfront users who frequented that site to discuss and promote their hateful ideologies, who used that site to target victims, to organize rallies, and more. And finally, they did something. They heard our demand and they pulled Stormfront offline. Stormfront went dark for the first time in its more than 20-plus year history as a result of this effort. And it sent white supremacists into a tizzy. This was their main hub to organize, and we did it on the heels of Charlottesville at a moment when the white supremacist movement had kind of a lot of dangerous momentum behind it. So this kind of disruption and obstruction, we think, is really critical in the fight. Stormfront, sadly, is back up today through a Canadian website that has a very different view on these issues, and basically doesn't have standards that it puts in place for consumers. But I nonetheless deem this an important moment in the fight against modern-day white supremacy. We have to figure out how we shut down these online hubs that make it so easy for them to carry out their hateful violence today. You think about what happened in Christchurch, New Zealand, where a white supremacist broadcast his massacre live on Facebook. All of these platforms have a role to play in the fight to end dangerous white nationalism in our country and across the globe.
And again, there's nothing that violates the spirit or letter of the First Amendment in an organization such as yours, using whatever moral clout and influence you have, even outside the courtroom, to go to private companies and say, "Hey, you should be doing this," and that's what you've been doing, and also through the courts. I mean, that it seems like that's these victories in court, like the one you had recently for Taylor, seem important in bringing greater public attention to who these groups are and what the differences are between what may be acceptable, well, maybe not acceptable, but allowable under the First Amendment, and where that speech crosses the line, and how the courts and how the law can be used to fight against those breaches.
I mean, look, lynchings, were not a form of protected free speech activity or free expression. People are dying and being assaulted, and as civil rights lawyers, we deem it our right and responsibility to use the tools available in our arsenal to fight back and protect victims of discrimination, particularly those who belong to protected classes that have been frequently targeted for hate throughout our nation's history. This is not First Amendment protected activity. I fear the day when we have to live through another massacre of peaceful worshipers, as we saw in Charleston, massacre of Jews inside of a synagogue. I fear the continued burning of black churches, as we saw recently in Louisiana. We have to fight back, and we should not use the First Amendment to shield the deaths and assaults that are happening across our country. El Paso requires that we, figure out how can we act to prevent, that kind of massacre from happening again. These are not issues of the past; they are with us right now. Hate is alive and well across our country and intensifying. The latest data from the FBI shows a 17% increase in hate crimes, and we know that percentage is growing. So it is time for us really to push to find the political will and the courage to stand up against the perpetrators.
Now, your use of the public accommodations law in the District of Columbia, Kristen, I mean, something that was so important during the civil rights years in the 60s. Most states have similar public accommodations laws, that is, that you can't be discriminated against in the use of public accommodations like hotels, restaurants, and other type of facilities. Do you see other lawsuits like the one that you brought on behalf of Taylor being brought in other jurisdictions where we have these same types of laws?
We sure hope so. El Paso, for example, that deadly massacre played out at a Walmart. We need to make sure that, that there was the shooting where we're still trying to uncover motive in Ohio. It's important that our public establishments, our stores, our hotels, that these kinds of public establishments be places that are free to all regardless of race. And so we do think that our public accommodations theory in this case definitely opens up a new avenue to be explored by litigators, and we're already vetting calls and inquiries from lawyers who want to explore this strategy as a way to stand up for impacted victims in other states.
That's great.
So at a time where we see the Justice Department, unfortunately, not doing enough to fight back, we are encouraged by the victory that we achieved in our case and hopeful that we will see other litigators and targeted victims embrace this theory as another way to stand up to white supremacists.
And I understand Taylor graduated from American University and is now in law school. Is she planning to pursue a career in civil rights law as well?
She is very interested in social justice and racial justice and has pursued internships that have given her the opportunity to get that kind of deep experience. And we are really excited to see where she goes after law school and how she uses that degree. But I'd put my money on her being a future civil rights leader and a voice for vulnerable communities in the future.
Well, I wish her the best in that, and want to thank you as well, Kristen. Kristen Clarke, the President and Executive Director of the National Lawyers Committee for Civil Rights Under Law in Washington, and the lead lawyer in Taylor's successful lawsuit against this neo-Nazi website and the students who were involved in perpetrating hate crimes against Taylor while she was a student at American University. So, Kristen, thank you very, very much for being on Good Law, Bad Law. I appreciate it greatly.
Thank you for having me.
We have a PS to the episode. I want to bring Kristen back into the conversation because I think there's something you wanted to mention about the suit you helped Taylor win. It's a very interesting and I think important and encouraging part of the case that I know you wanted to tell our listeners about.
Yeah, we secured a settlement with respect to one of the named defendants a few months ago. This was a particular defendant who was prepared to renounce white supremacy and prepared to basically be held accountable for his role and his actions. He's agreed to do a number of things beyond renouncing white supremacy. He's agreed to issue an apology to Taylor. He's agreed to undertake community service, take courses on racial justice, and cooperate with us in our continued efforts to pursue other white supremacists, among other things. We think that this settlement is groundbreaking in that it shows that there isn't necessarily a one-size-fits-all approach to the perpetrators in these cases. It's very much a settlement driven by principles of restorative justice, and we're hoping that it provides yet another vehicle for thinking about how we can turn the tide on white supremacy in our country.
That is really encouraging, and I think gives people hope too that the people who, there may be, and I'm sure there are lots of incorrigible individuals and irredeemable organizations, but there may be some who are also susceptible to the kind of settlement that you were able to make with one of these students, and I think that's great and really inspiring too, because it shows again a different dimension to what this type of action can bring about. I think that's fantastic. If we put a link to the website for the National Lawyers Committee in the description. Can people go to that website and get a lot more information about not only this case, but some of the other initiatives that you're involved with?
Absolutely.
Okay.
Absolutely.
Good.
We have the Lawyers Committee website, and we also have another website, 844-9NoHate.org.
And just briefly tell us again what that initiative is involved in.
Yeah, that is a website that provides resources and information on our national program to combat hate. Working to confront hate crimes and white supremacy is an important part of our work at the Lawyers Committee for Civil Rights Under Law, and this is a dedicated website that's focused on helping communities and victims who've been targeted by hate.
That's great. Okay, so we'll include that as well. And again, Kristen, thank you so much for your time and for talking with us on the podcast today. I really appreciate it.
Thank you for having me.